Well, I am back to harass you again, and we have a
Who
great
is this?
show.
What?
I
Oh
know,
yeah,
I know. I heard you're
yes you did.
renegotiating my deal. I'm gonna have to
That's
get my
right.
agent,
I'm gonna have
Valjean
to
and
have.
Tupi, to talk to you.
I'm gonna get Mark Randazza on this because I think there's a freedom of speech issue. Anyway, hey folks, welcome to Justice Serve TV. Michael Bryant here, Linda Kenney Baden back in the chair, which we appreciate. And we have Mark Bederow tonight, and we'll get into a little bit about the Walshe thing, a couple of other bits and pieces going on. Stay right where you are.
Justice, where are you? Michael and Linda are here.
Love you, Linda.
Where is justice? Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down me, I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
All righty, Monday. Hope everybody had a great weekend. Did you have a good weekend?
I worked all weekend.
Well, that's a good weekend for you.
It's a good weekend. I love it when I'm in the heat of things, as you know.
Mm-hmm. Well, heat would be good. I think I just checked. It was 24 degrees. I took Domino for a little evening stroll, and freezing my ass off out there. It is very cold. So, yeah, I'm done with that for the night. All right. So, without further ado, we're going to do our rip reading stuff and a few other tidbits with Walshe in a moment or two. But we want to take advantage of our good fortune to have with us Mark Bederow. Sir, how are you?
Good. How are you guys?
Pretty good. Should I just jump into last Friday? Should I just do that? I mean, everybody who watched that, which was another Norfolk cluster, trying to figure out who could look at it, who can't stream it. I mean, it's crazy. Anyway, you guys appear, and you're there to talk about, we hope, something of substance in the Aidan Carney matter with these two pending charges that still are hanging out there for witness intimidation. New judge. Give me your visceral reaction to him. I don't know if you've had history with him or not, but what'd you think about Judge BZ?
No history, just, not a Massachusetts lawyer. So, but like anyone else, you put feelers out, you ask the Massachusetts people, what do you know about this guy? And all feedback was good, to be honest with you. It was very, very good. And I think that was borne out in the proceeding. I thought he was efficient. I thought he ran a good proceeding. He put the conflicts issues out there front and center, and I had an agenda. I mean, it was clear. I have no complaints, and I think it's just good that we have a judge as opposed to the problem we've had in this case. It's a complex case. There's just so much going on. It just gets shuffled every couple of months, and it's really hard to keep up. And, we have a judge. It's fine. And, we get to go to Boston instead of Dedham. So that's a win, too.
I had to tell you, people have been saying that Michael and I, because we were kind of fighting a little bit on the show. We weren't fighting. We never fight.
We had a healthy disagreement. It's all right.
I was of the view that this was a good move. And, of course, I love Boston juries. I mean, I love Suffolk County juries. Mm-hmm. And I thought that jury, a Boston jury, they get it. They get things really good. And so I was really happy with the way things turned out. My cohort here, who I love and adore as my co-host, even though he is, having feelers out to replace me because I've been gone so long, it wasn't so happy with it.
Yeah, Mark, did you get my note about that? Oh,
no. You didn't like the way it went?
No. We were just talking about. We're giving her a hard time because she was busy last week, and so I may have talked to a number of people about filling in. Anyway, go ahead.
No, I mean, look, there's no complaints. It's fine. He also did what we wanted, which was to bifurcate the conflict issue from all of the other issues, which, at the last discussion about this, which was in front of a different judge involving a whole number of issues, including Karen Reed's cell phones, that whole fiasco. The answer at that time was just, we're going to do everything on December 5th. And then, in between then and then, what happened? A new judge was assigned. They didn't file their motions on time, so the date had to get changed into a status conference. and we got the bifurcated proceeding out of it. So I think that's actually a good sign that everyone agrees and recognizes that if there's a conflict, we shouldn't be talking about the guy with the conflict writing motions to dismiss cases in which he, our view is has no right prosecuting in the first instance. So yeah, no, we're happy.
Even if he does write them in the royal we, in terms of looking at his papers. But with regard to that, I thought it was interesting that he said, well, if you conflict me out, Judge, there's no reason for me to be the other cases. Now, me being Italian and being a little bit suspicious of things, I'm thinking to myself, well, yeah, you don't really want to try anything where, you may be able to try to stack the evidence, or maybe you'll get more money because it would take longer. So I thought that was an interesting comment from Mr. Cosgrove, who, by the way, Michael Bryant has named Cosgrave.
Right. Well, until he learns how to pronounce Carney's name properly, he doesn't deserve to have his name properly pronounced.
I thought the comment about if you kick me off the one case, I'm going to quit on the other is actually very interesting, and something that we will address in our written response, for the simple reason, why so interested in the case with the obvious conflict, but no interest at all in the other one, in which there is no conflict, in the 25 window intimidation case. It has nothing to do with the witness at issue. But then again, why the interest in the other one? And is that professional? Is that personal? Is, again, the appearance of all kinds of things? That was a strange comment, I thought, actually.
There was a moment in the hearing, speaking of Cosgrave, when he started talking about some of the discovery and attributed to you some of the material that he had just received, which hopefully will get to you at some point. And I could see there was that moment you were like, you're letting it all play out, but clearly you caught him in this confusion. And it took him a while before he recentered. He did
correct himself. Yeah, he did.
He did finally catch himself. Let me ask you about what you've really gotten and what you haven't. Have you gotten anything since Friday?
No. I mean, the check's in the mail. We accept that representation.
Yes.
The mail hasn't arrived yet, apparently, though. So we don't have anything new since Friday. But, the problem that we raised is that, the system, as you know, can't function if you can't rely on the good faith of the prosecution to fulfill its obligations. And again, the court accepts generally, unless there's proof that they haven't complied with, that any representation they make is accurate. And you would hope that's the case. I mean, again, you can't have a civilized criminal justice system if literally you can't trust what the prosecution is saying most of the time. But in this case, we have no clue whether they've complied or will comply with their discovery, because they've said time and time again that they have. Then other stuff shows up. Other stuff shows up on Twitter that we don't have. Other material that is clearly discoverable and in certain cases exculpatory shows up in freedom of information requests that have nothing to do with them fulfilling their discovery obligations in a case like this. And, you saw the other day on Friday, something I've never heard in almost 30 years of this. The now recused / dismissed former special prosecutor has a grand jury exhibit from 2023 that he found and is handing to you in December of 2025. And, I only just got this. The state police were not aware of this, and I was not personally aware of this. And of course, as lawyers, we all understand, legally speaking, that means bupkis. I mean, the Commonwealth is the Commonwealth is the Commonwealth. The cops, the DA, the victim witness advocates, the paralegals, they're all the same entity for purposes of possessing evidence, and they're obligated to turn it over. And just the idea that this kind of thing is not being turned over. One of the other things that was referenced, I think you heard the other day, there's allegations and there's testimony to the effect that there are all kinds of harassing messages that are attributed to a certain person, defendant, who allegedly either harassed or had other people on his behalf, or people aligned with him harass their most important witness in Facebook messages, which were allegedly disclosed to the DA. I mean, that's in testimony. The idea that it was actually disclosed. And that testimony would have occurred sometime in 2023. It's now the last month of 2025, and we don't have any of that. If it exists, I mean, you know, whether that's truthful testimony or not is part of the problem. That needs to be determined. But in any event, you'd think that a prosecutor would pay more attention to something like that and be concerned about, A, why wasn't this disclosed if it's obviously discoverable and important, and B, perhaps more importantly, if it doesn't exist and it wasn't disclosed and there's testimony from their witness under oath saying, I received it and disclosed it, what does that tell you about that testimony? That's troubling for other reasons, and that would be Giglio material, which is the same thing as Brady material anyway. So we just want what we're entitled to, and frankly have no confidence that they've turned over everything they're supposed to.
Yeah, how could you?
Yeah. Well, you know, going back to Michael's comment here about just the judge, because I do think, I mean, you know, you've been very talking good about the judge, and I think he seemed very fair. But I go back to Cosgrove, and when you talk about relying on him, if this man, and I think he pronounces Aiden's name wrong purposely after the judge specifically asked Aiden, how do you pronounce your name, right? And I love judges who do that to both our clients and for us, right? Because how many times do our names get pronounced?
Sign of respect, fairness.
A sign of respect. There you go with the issue of respect. So then he, again, in my view, purposely mispronounces Aiden's name as Kearney rather than Carney. And I think that is a true sign of disrespect, and also how he plans to disrespect him in this proceeding that you have going on, that you can't seem to you know, get your teeth into, because you haven't had a judge that would be fair to the defense. And then we're still sitting out there with Cosgrove and Judge Krupp. So talk about that interplay.
I mean, he's trying to search cell phones that were seized in early 2024, and, you know, warrants from January of 2024. Though the probable cause affidavit to seize the warrants but not search them, which is bizarre. You know, that's not how we would do it in New York, for sure.
For sure, Jersey.
Yeah, I mean, they would have gotten the authority to do both. Taint team issues aside, understanding there could be privileged communications and all that. But in any event, they seized these phones in January of 2024. The probable cause affidavit is prepared by Tully, and it's primarily based on two major informants. And this is all public record. I mean, actually, Cosgrove has filed this, and this has been discussed. But one of those two major sources of probable cause for Tully is the witness who is suing Cosgrove and Tully. Okay, she is probably anywhere from, off the top of my head, 8 to 10 large paragraphs of, you know, alleged facts which support probable cause to believe that Karen Reed's cell phones would contain evidence of her and Aiden Carney, you know, committing conspiracy to commit witness intimidation, whatever. So they took possession of those phones in January of 2024. They inexplicably never sought a warrant to search the phones when they seized them. Then in March of 2024, Mello went before the grand jury and sought to indict Karen and Aiden together for conspiracy without the phones. So they rushed to get the phones, but they apparently were not so important that they needed to get them for the grand jury. So they ran to the grand jury in March of 2024, which everybody knows returned a no bill, which is extraordinarily rare, particularly where a defendant doesn't testify, and particularly where the two targets are respectively under indictment for murder and witness intimidation. So they didn't do that. So it begs the question, why run out to get the phones, not even seize them, and run to the grand jury? And I think this is where the bad faith comes into play. And, you know, it'll be interesting to see if Karen's legal team, this is more their battle than ours, gets into the bad faith of the request now. It's pretty obvious they ran to the grand jury in March of 2024 because her trial was starting April 1st of 2024, and they didn't want to wait, and it would take time. And they wanted to bang her with an indictment right before her trial. Lots of news, potentially revoke her bail, but either way, get it out in the press that this was going on. I mean, I think it was clearly a rush to indict to gain a kind of dirty advantage in her murder trial. And so nothing happened. The grand jury declined to indict. She goes to trial twice, is acquitted, in my view, twice. And then after the trial, the now new special prosecutor says, well, I think I'll search the phones and demonstrate the existence of a conspiracy to commit witness intimidation of witnesses who testified twice at trial that the jury rejected twice. You know, where but Massachusetts would this happen?
Exactly. I know it wouldn't happen in
considering. I mean, that's where we are.
In
You
California.
can't have, to me, you can't, yeah, and you can't have any more bad faith to me than you have here. The fly in the ointment is Judge Krupp, who signed the original search warrant for the phones, knowing that the trial was coming up. That's what bothers me, because I don't trust the system. Now, I know you guys are very good. I know Aiden's representing so incredibly well by you and Mr. Bredel, but I just don't trust anybody up there. But I think they may have a little bit more of a problem. They're going to be in a bigger to me, by being in Boston, with the Boston press and the Boston media, now this is going to be, to me, a bigger story. I don't know if you feel that way, but I think now that you're going to be located there, they may even pick up the story even more than they have.
I mean, I do, in the sense that Boston's the big city and the media outlets, it's just natural that, I mean, look, generally speaking, cases in Manhattan get more coverage than cases in Brooklyn, and cases in Brooklyn generally get more coverage than cases in Queens, and cases in Queens get more coverage than cases in Staten Island, and so on. I mean, when you go to the city, you're going to get more. I mean, we're only going to be there necessarily for one or two appearances, depending on where the judge ultimately ends up. I mean, I have no doubt we're going to end up back in Dedham at some point, but I do think that these oral arguments on kind of the juicy issues that have to be litigated being in Boston, yeah, I think that's a good thing. And I mean, frankly, I just prefer the big city anyway. That's kind of culturally the type of courthouse, the type of environment that I'm more comfortable in than the, like going out deep into the suburbs. Not that Norfolk is that deep into the suburbs, but I mean, I just much prefer the center city and that environment. I think that's better for us.
There's something that something you said there suggests that you're realistically facing what might happen in the recusal and motions to dismiss. No matter how well you've prepared them, documented them, the odds of winning, in my opinion, either of them is difficult. And so you're looking down the road. Would you agree with that?
Well, I mean, you always have to. I mean, you can't assume that motions get granted. I mean, it's interesting because, in the Twitter universe and Twitter law school, everybody judges every argument, every motion, every statement, every comment as this be all end all huge win or huge loss. And what a big deal one way or the other it is. And of course, in the real world, that's not how lawyers operate. I mean, you have a long game strategy. You realize that there are skirmishes. Sometimes there are battles. Sometimes there may even be major wars before you get to the big one. And, some issues are bigger than others, but it's not all eggs in basket. Everything goes down. I mean, there is clearly a long-term strategy. And in the event, you don't win this, what are you going to do? Of course, that's all thought out, planned, and in the process of being planned. Look, for us, the motion to dismiss is fascinating, but it's one that never should even be revisited in any event, because we believe the conflict is, it's off the charts for a number of reasons. And the public confidence in this prosecution, which already is probably pretty low, the idea that it could continue with a prosecutor and lead detective being sued by someone whose name is going to come up, who could be a witness for either side in this matter, when you already have a situation where the DA's office itself had to be recused because of a conflict. The first special prosecutor had to be kicked off because of making himself a witness, having another form of conflict. And now you go to this. You have the state police that are involved. They have an egregious conflict. They should have been recused immediately in this case. I mean, these are the very people that are investigating this case who are criticized and called corrupt in the Karen Reed case. And that's what led to the investigation to the witness intimidation case against our client. So, I mean, the conflicts in this case couldn't be more obvious. They couldn't be more suffocating. And there comes a point where it is being raised pre-trial, which is a big distinction from, on appeal, where on appeal, you'd have to demonstrate actual prejudice and does it impact the outcome of the case. But when it's brought to the court's attention pre-trial and there's an appearance of a conflict that, is really not waivable, it could impact the defendant's rights, and there's a clear break in the interests of the government, the Commonwealth, which is to pursue justice, whatever that means in any given case, and a personal prosecutor who has been embarrassed, is being sued, and has an interest in destroying someone that he called as a prosecution witness just a few months ago in another trial and vouched for her credibility. It's absurd. It really is the kind of thing where you ought to just step away and just bring in somebody new, assuming they're willing to do that. But the idea that they're defending this conflict with such fight, given what it is, I mean, you're being sued. The lead detective is being sued. The lead detective is going to testify. The lead detective is going to have his credibility attacked about a number of things, including his conduct with the witness who is suing you. It's going to come out that she is suing the lead detective. You then are going to defend the credibility of the lead detective. Ought the jury not have the right to know that maybe the reason you're doing that is because you're getting sued too, my man?
Mm-hmm.
Now, obviously, the jury should not hear that, because none of this should be before the jury, because the conflict is so obvious. But if they don't have, if this is not addressed, this is destined to come out, blow up in the middle of trial, and lead to a mistrial, which will be the fault of the prosecution and ought to be the end of the case. But it's so obvious that that's the path this could go down. It just seems that in any sane legal world, the answer is maybe we should find a non-conflicted prosecutor to the extent we can, which is another issue.
To the extent that anyone would take this. I mean, you have to, if you have a good attorney or an ethical prosecutor, and you and I both know good attorneys and good ethical prosecutors. We both dealt with them. We both deal with them to this day.
No prosecutor would touch this for a number of reasons, not the least of which is, you're charging somebody with witness intimidation. These are all acquittals on the cases in which they were allegedly intimidated. In other words, the guy was right, essentially, factually. You can agree or disagree with his manner, his method, whether he's obnoxious or not. That's all fair. But, he espoused an opinion on guilt or innocence. Jury, they don't do guilt or innocence. I get it. They just do, not guilty or guilty. But practically speaking, the jury agreed with him. So you have acquittals. And then what's happened since then? There are lawsuits flying back and forth, and all of the witnesses who were allegedly intimidated have now been sued by Karen Reed for, being involved in their own conspiracy, allegedly to violate her civil rights. In the case of Tully, he's now been sued twice. He's been sued by the witness in our case, and he's been sued by Karen Reed. The prosecutor in our case has been sued. The witnesses against Aiden are allegedly threatening to file their own lawsuits, which, if that's what they want to do, bring it on, go ahead, do whatever. But if they do that, that also gives them more of a motive to falsely, or be biased in his trial. They have a financial motive in seeing him convicted. At what point does some prosecutor say, you know what, you guys go march down to civil court and throw darts at each other? I'm not taking taxpayer money. I'm not wasting important resources on this. You go fight it out. Good luck, Godspeed. But this is not the role of a prosecutor. But here we are.
Yeah, here you are. And at some point, I guess the question that Michael Bryant, who's sitting there, is talking about is, why doesn't the judge just take home and get rid of all this? That's what he feels, because what you just espoused is so incredible and so ridiculous and so outrageous, and so clearly we just want to get you at all cost, Aidan Carney, especially since you've taken us all down. You've taken the Massachusetts State Police down. You've taken the system down. You've exposed corruption.
Well,
that a judge would say, goodbye, so long, farewells, Commonwealth.
At least on January 23rd, as it relates to the conflict part of this, I intend to get my money's worth in espousing all of this. And, we're going to put some of this in writing beforehand and raise some other points in response to the papers that we just got, a couple of hours before the court appearance, opposing the disqualification motion, whatever. That's not something you usually see either, the timing of that. But I will hopefully get our money's worth on putting this all out there on January 23rd, including emphasizing, there is a public interest in having confidence in the system and an appearance of shenanigans being afoot. And this case is the poster child of that, whatever your feelings are about the defendant.
Yeah, there's nobody that gives anybody the benefit of the doubt, from my perspective. And how can they, after what they've seen over the last 2.5 years? It just continues to become even more absurd. So let me ask you this: what frustrates you more?
Oh boy.
These issues with personnel involved, or just the simple fundamental discovery battles on every single thing?
Discovery, for the simple reason the discovery issue is a fundamental rot in the DA's office. That is cultural, that is systemic, it's pervasive, it's a problem. I mean, the personalities, those are just the litigants in this case. But, in the limited time that I've been involved in these Massachusetts cases and watching some of the other ones, from what I've seen in the 3 or 4 cases, there is a systemic problem in the Norfolk DA's office related to having a system of ensuring that discovery is provided, having a care in the world that discovery is provided, and when it's not, having a care about how to remedy that and do it so that a defendant gets a fair trial and that they honor all of their constitutional and statutory obligations. I mean, the stuff that goes on there with the discovery, and you can see that it's cultural, okay? And the reason I say that, and this is no disrespect to Cosgrove, but he was a judge. So he is entrenched in that system. And the response the other day was, we have a grand jury exhibit they say they didn't get, but I didn't know, and the state police didn't know, and Mello just fished it out, and here you go. And in what world is that okay? It's not. All that stuff related to Jennifer McCabe, we've asked for that. It's not okay. Even several weeks ago, when the motions were due and a motion for an extension was sought, and as part of that motion, it was represented that Mello claims he found other relevant materials that are important. We still don't have those. We don't know what the hell they're talking about. We don't know why things don't get disclosed. And the general attitude appears to be, what's for lunch, right? I mean, now, to this judge's credit, when we raised some of this and said, I don't understand for the life of me, if the answer is, well, Mello's finding drips and drabs, go to his house and office and collect what are we doing? It's your obligation. And the judge said, I'm not going to force them to do that, which I understand. He's not literally in the role of telling them how to do their business. But he did say, if you don't do what you're supposed to do, there are grounds for sanctions, which is the first time that has at least been mentioned in any serious way, that, if you have evidence that you're not disclosing, turn it over. This idea that they couldn't get an affidavit from Mello. I mean, think about it. We accused him of really bad misconduct, pervasive misconduct. The ordinary course in responding to those kinds of motions almost anywhere would be to dispute that with a sworn statement of the person you're accusing of misconduct. And if their position is, I did not engage in misconduct, to deny it and explain why the lawyer, us in this instance, are crazy for saying we did. And here we can prove or at least create an issue of fact to be resolved at a hearing. And the answer here was, I can't format a Word document, so you tell me what you said, and they avoid a sworn statement that way. That's absurd.
Imagine a federal court countenancing that in a federal crime. Never would happen. New Jersey, never would happen.
So the answer to the question, I guess 10 minutes later, is the discovery stuff is more bothersome because it's more part of their systemic rot than just the personalities and the oddities of this particular case. You saw it in Karen's case with the Sally Port video and God knows what else. You saw it in the Miles King, where apparently search warrants in a murder case take years to disclose, and 2 out of 6 pages at a time. Crazy. You've seen probably other cases. I mean, it's just clearly they don't have a mechanism in place in that office to make sure that these things are being done. And these are on their cases that are high profile, which is also very scary. These are generally defendants that have very, well-paid, well-established, highly credentialed, skilled lawyers. Obviously, that's the case in Aiden's case. No one's going to dispute that. Thank you. But Karen's case, obviously, in the King case, Rosemary Scapiccio obviously is, an A+ top shelf lawyer. I'd be worried about what's happening in the lower cases where the so-called schlubs are defendants who can't afford those kind of lawyers, who don't have the bright lights of the coverage of people like you or all the other, people who cover these kinds of things, or just the publicity. What the hell's going on in the darkness? I mean, these cases are in the light. So to me, it's the discovery issues with the office as a whole.
Yeah, they're getting steamrolled. That's what's happened to those folks, and they're getting crushed by the system. And so it gets me to my original concern, Linda, about the new judge, and that is who's going to have the stones to give real consequence to these flagrant violations. Because what happens is over time, everybody in the office, and as you suggest, Mark, it carries on to the extensions of each office, are all under that umbrella. They just don't care because there's no consequence. Somebody's got to create a consequence that gets their attention.
I agree. And the issue here is, and then we'll say this on the 23rd of next month. If you don't disqualify him, he's going to try the case, and these people are going to testify. They're going to be cross-examined, and it's going to come out. And we're going to be potentially examining this witness and then talking about a lawsuit and who the defendants are, and pointing at the guy at the prosecution table saying, that guy, the one sitting right there who's now looking down, or, that's the guy you sued, right? This guy. In what world would any prosecutor say that's a better outcome than just saying, I'm out, when you've already recused yourself voluntarily on another case? But they're drawing the distinction between her being an alleged victim, and now, if you look at the recent filing, well, she's not an essential prosecution witness anymore. Okay.
Anymore, right.
If that matters. I mean, so suppose she's a defense witness. Like, for example, this witness has alleged that other prosecution witnesses, that she's aware of things that are very discrediting to other prosecution witnesses. So we certainly have a good faith basis to cross-examine those witnesses about that. If they deny it, we could very well call Lindsay, her name, to testify about that. We've alerted the prosecutor to these credibility issues. Is he looking into this? Because again, it's in the Commonwealth's interest to do justice, and doing justice is making sure they're doing the right thing, whatever that means. Doing the right thing means it's in the Commonwealth's interest to ask not only Gaetani, but the witnesses that she's alleged have done wrong things to investigate that, to determine whether it might be true or not. They're not going to do that. Their position is going to be Lindsay's lying and Jennifer McCabe and the other witnesses are all telling the truth.
So that leads me, let me interrupt you there a second, because that leads me to a question we have from somebody, because doesn't that put her in legal peril from the Commonwealth by Cosgrove staying in, which is another issue that she may have, right? If she's lying, you're talking about them maybe bringing a perjury charge against her.
I mean, he point blank said, we believe if she were to be a witness that, she should have counsel assigned or retained counsel who explain to her what perjury is, and that she could be exposing herself to perjury charges. Is that the position of the Norfolk DA's office, or is that Cosgrove's personal shot across the bow to silence her? Again, the lines get blurred here, and some people are running around saying, oh my God, he's threatening her with perjury. I'm not going to go that far, but these are strange things to put in a response. And there were many strange things, I thought, to put in that response about the witness, about her personal life and things that one usually doesn't see a prosecutor write about, a young lady in a public filing in a case that's, very of high public interest. And by the way, let's not lose sight of the fact every time something embarrassing is put in a filing, in this case about the current witnesses that support them, protective order or impoundment. I mean, it's like, death, taxes, and impoundment. That's how it works there. Not this. This was a nice, loud, public, attack on Gaetani about her personal life for everyone to see. Now, some of those things have been said by others previously, but it's not the kind of thing you usually see a prosecutor do. And you wonder again, is that personal animus? Is that the line being blurred again? Is that prosecutor, or is that I'm pissed off because she sued me when I don't think she has a basis to do that? Either way, it looks bad. It creates this appearance of an obvious conflict, we believe.
And then all this, to remind everybody, is obviously you want to win the battle. You want to get the case dismissed. You want the not guilties. But all this is also in light of the fact that you have a statute that's out of control under the First Amendment in Massachusetts, that if your feelings are hurt, basically the common parlance, that could be witness intimidation, which is not only outrageous, I think it's totally unconstitutional. I think it's unconstitutional. I think the Massachusetts Supreme Court would find it's unconstitutional.
I mean, if you read the statute literally, you could have these journalists from all kinds of TV shows who run around confronting people outside the courthouse, knocking on doors, saying things that hurt people's feelings. You could make an argument, well, that hurt me and I don't want to go back to court. I'm scared. So I think that they were trying to get me not to testify. They could be liable under that statute. They could have legal analysts. I mean, you could have people like us talking online saying, I saw that witness testify today, and God, that witness, in my view, was lying, was not credible, is really potentially going to expose herself to this or that. She says, well, that's embarrassing and that hurt my feelings, and now I'm scared to go back. Am I now guilty of witness intimidation because I said that on television? I mean, you could make that argument, as absurd as it is. So yeah,
everybody at Fox News would be indicted for having a microphone under somebody to try to get a comment. Everybody at CBS would be indicted for. Yeah. I'm not picking sides. I have a microphone under somebody to make a comment, as you saw in 60 Minutes for many years. I think it's outrageous. I mean, I think it's on that basis is outrageous. And no one wants to seem to jump in, except you did have the Attorney General who wouldn't take these cases, right?
Yeah, the Attorney General was asked on multiple occasions by the DA's office, and they completely declined, much to the chagrin and disdain of the DA, which again, we only learned in emails that were in a FOIL request, not necessarily disclosed to us, but they were publicly put in a FOIA request or response to a FOIA request.
Yeah. It's going to take somebody convicted under the statute to appeal it and take it up and let some reasonable minds, take a look at it. For me, and I'm embarrassed to say this, when I'm out in the field and I'm in a courtroom, like I was down at Adelson, I'm talking to just generally witnesses who are queued up to go in to testify. I mean, hey, who are you? What do you? I haven't done that when I've been up there in Dedham for this Walshe case we're covering, because in the back of my mind, somebody could say I'm trying to intimidate a witness.
We have cataloged probably 24 at least examples of people who were screaming at Karen Reed, her lawyers, during the first trial, the second trial, making all kinds of nasty comments, calling her a murderer or various things, or just saying nasty things, or accusing her of salacious things with other people, and accusing the lawyers of salacious. And the lawyers are covered by the witness intimidation statute, by the way, in Massachusetts. All these salacious details. Those are all examples of witness intimidation. I mean, if you're going to do this, let's do this, or not.
Yeah.
Or
So when somebody is accusing somebody of witness intimidation under a Massachusetts statute, it's because the way the statute is written, and it may be all encompassing here.
Yeah.
So, and that's what Baden's being prosecuted.
Yeah, and they talk about potential witnesses, right? I mean, that's how they define it. Well, in Karen's case, Karen was a potential witness. I mean, she very well could have testified. She certainly had a right to. She doesn't have to. So just because she was the accused does not make her that she can't be a potential witness. And they're screaming all kinds of terrible things at her. There were online threats that were directed to her at some point. Who's investigating that? Nothing. The only, and that's the other thing, is that the statute is enforced in a content-based manner, which is a whole nother reason to not allow this. I mean, if you throw a rubber ducky that says, free Karen Reed, that's apparently, some form of witness intimidation. But if you make threats online, as long as you're on the right side or the wrong side, it doesn't matter.
Yeah. And there's definitely selective enforcement. There's no doubt about that.
Clearly.
Yeah.
Yep.
I know people are interested in how the Commonwealth can go back to Judge Krupp on the phones, and how can the Commonwealth try to get another indictment on the phones for Karen Reed. I know you said that's really her fight, but that's because what the Commonwealth, I guess, will say is, we never searched the phones, so we didn't put that.
I mean, I don't want to speak for them, obviously. What I really hope they do, though, is make the full-throated argument that they're entitled to no grace. They had these phones in January of 2024, and they did nothing except trying to indict her without the phones, and they lost. And then she was acquitted twice. And now, after all this time and 2 years later, now can we search the phones and pretty please let us try to indict her again for the same conduct in which we initially failed when they weren't diligent. They showed no investigative interest at the time in what they were doing. And it calls for a judge to say, not on my watch, no. And I really hope that they make that argument, win or lose, that this is just wrong, what they're doing and the timing of it. And there has to be an end to this. I mean, the problem is they treat these people, Karen, Aiden, whoever, like they're Moby Dick. They just can't stop hunting the great white whale, no matter what. I mean, they're obsessed with this.
It's frightening.
And they have a perfect out. They're all fighting in civil court. Let them have at it. We're done.
Where do you think that comes from, Mark? Do you think that's just inbred there because it's family upon family? They grow up in the system, and my dad's a cop, my granddad's a cop, and he's an attorney for the DA. And it's so incestuous that they just feel entitled.
Yeah, I think again it's the culture of rot, and it starts in the head with Michael Morrissey. He has a horrible culture in that office where they have that embedded unit of detectives. They all hang out. They're all bros, right? Look at the way they all talk to each other. They all go out drinking together. They go to lunch together. They donate money to Morrissey. It's the same cops on the same case, and they become too close and too friendly, and lines get blurred. And that's the corruption. I mean, the corruption It's not the kind of corruption where somebody's slipping an envelope in a smoke-filled bar. The corruption is that judgment gets clouded because you're covering and biased in favor of friends. And when it turns out that some of these people's friends are also cops and a powerful family, I think the lines blur and it just all blends into one, and you end up with this. And when you have a DA who's been DA for life, he's been in government for far too long. It's time to go, clearly. This is just the way they do it. You just become drunk on power and complacency, and you do it because that's the way we do it. And if you say, well, that's not really a reason, can you explain that? And he says, yeah, because that's the way we do it. I mean, in some ways, it's like, talking to a child. Well, because. Well, why? Because why? That's how we do it.
This is the way, to quote the Mandalorian.
Yeah.
Well,
yeah.
also because this is the way, as I always say, for every wrongful conviction in the country that we've seen, there's a judge sitting in that courtroom, because the judges haven't taken a stand and said, no, this is not going to be the way you're doing it. Out the door you go. And I think until we get some courage on the judge's bench, we're going to continue to see that. I always talk about that.
And you didn't see it, like in Karen's case, the whole thing with the Sally Port video and the inverted video.
Yeah.
How the hell that case did not end in a mistrial with the inverted video and the non-disclosure in the middle of trial, to this day, I don't understand. I literally do not understand how the case didn't end. And when they got to the second trial and we found out that the explanation was that all that inverted video or all the whatever video, Proctor held it and he just forgot to or suppressed it from Lally for 2 years.
Yeah.
And they're moving to dismiss for intentional misconduct, and a judge in that county doesn't even find that a basis to explore by taking testimony. Well, that's where you get the old forget it, Jake, it's Chinatown thing that I always talk about. I mean, it's just the way it is what it is. It's forget it, Jake. It's Dedham. I mean, that's what it is.
Yeah, one of our interviewers wanted us to ask you. I'm not going to ask Carmen Dharma I'm not going to put Mark in that position. How bad is Adam Lally? All you can say is that he's part of the prosecution team that let this happen. I mean, it's simple as that. He sat there, and I'll answer this. Okay, he sat there when Hank Brennan put up that shirt, okay, knowing that the road rash on the shirt that was like, don't get me started because I'm going to go crazy. I'm just going to calm down. Yeah. Knowing that what he was telling the jury was not true, and he sat there more like not just like a potted plant, but like a potted plant, Jimmy Hoffa encased in cement, who's been dropped in the East River, okay, and didn't say a gosh darn word. So I will let Mark answer that. I'll answer.
But I don't have any business with him, and be happy to say what he did in Karen's case, the first trial and the second trial, including watching Brennan do what he did, knowing what he knew, that makes him as ethically responsible for the misconduct. Absolutely. And then when I saw the testimony that he gave related to the King thing and the search warrants in Proctor, and I said this to someone else publicly at the time, he should have been fired that day. He should have been terminated that day. He clearly was not fit to be handling these kinds of cases and has no real recognizable concern about a defendant's right to due process. Even somebody like Miles King, who may very well be a terrible killer, I don't know, I don't really care, it doesn't matter. The point is, he's a criminal defendant entitled to discoverable evidence, and Lally's responsibility is to turn it over. And he says, well, it's Proctor, I didn't ask, I did get a couple pages and I turned them over, and then what's for lunch. He should have been escorted out that day.
Yeah.
By the way, just off the topic a little bit, because we had talked about before the show began, Kyle Sharkey, who's a big friend of the net, wanted to know about Luigi Mangione Courthouse, because you were at the courthouse today. What was your view of the courthouse? See any protesters out there? Or was it just?
It was very quiet. I got there this morning, probably around 9:15, so before any kind of court would start. In all fairness, it was bitter cold in New York today. And I'm not sure that the Mangione protester types are the ones that are going to tough out the cold. I don't know. Maybe I'm wrong. No, there was no real activity outside, and in the hallways, I didn't really see much. They had a lot of security up there. They do that in New York for these big cases all the time, but it didn't seem that much was going on. There's press, there's cameras, and the lawyers walk by, there's snap photos and things like that. But it was not the circus that you've previously seen. Thank God.
Yeah. Really.
All right. So your next time in court is when?
January 23rd in Boston.
Somewhere. We're not sure exactly where, but somewhere.
Yeah, well, downtown. I know where it is.
It's Suffolk County Courthouse.
We don't know the court floor or the room itself, but
the courthouse is. We don't know what the courtroom is.
Yeah.
And that is purely to argue the disqualification motion, which is what we wanted. We wanted to isolate that before we even get to anything else. So, in that sense, Friday was a win.
Okay. So papers are due on the 13th, right? 10 days before. Got a few tricks up your sleeve with the paperwork?
Not tricks, just facts and law. But, there's a lot to say. Yeah, there's always more to say. The response we got was interesting. We'll just leave it at that for now.
Yeah, I'm going up the first week in January to do my trial advocacy workshop lecturing for Harvard Law School and Ron Sullivan. So I'm going to try out the new generation Acellas to get up there.
The Acela actually is pretty good. Do not take the regular Amtrak.
No, I know. I take the Acela. I've been taking this. I love my seat, but so I'll be up there. I assume it's going to be starting to be bitter cold up there. Usually as it is.
As bad as it is where we are, it's worse. You're 200 miles north. It's worse.
Yep. It's worth. Anything that you want to tell our viewers that we haven't spoken about?
No, just it's great talking to you guys again, and go Pats. I know you're Jets fans. So.
Yeah, well, I'm a Rams fan. So
I need to put a blanket over my head being a Jets fan.
We could have a reunion in one of those big games down the road, sir. So
maybe. Those games tend to work out well.
They have in the past. Yeah, most of them have. I was there, unfortunately, to see that.
Can I just say something in fairness about Jets? I do hope they have all those first round picks to go get Fernando Mendoza, who I love as a quarterback. But who knows? Yeah.
The idea that a quarterback from Indiana could be the most desirable pick, and that Indiana is the #1 undefeated team in the country is not, I think, what anyone would have said would have occurred in your lifetime. That is stunning. But yeah,
something that has occurred in my lifetime is the Jets would get to the playoffs.
That's true.
I mean, I'll be quiet. I mean, the Patriots.
You have to be quiet on that. So Missy wanted me to point out that today would have been Officer John O'Keefe's 50th birthday. It's also our friend Sherry Schreiber's birthday, and also. Everybody, has remembrances and things, and we wish everybody who has happy, healthy, and we hope that this case comes out well. I know how I want this case to turn out because I think there's only one right decision, and thank God Aidan Carney has you and Tim Bradle to represent him on that case. Mark,
enjoy the holidays. Try to take a breather and get back at it the first of the year. We look forward to talking with you further and seeing how this thing unfolds.
Sounds good.
Take care, man.
Thank you, Mark.
Bye.
And before I just want to point out that Kay Schmidt gifted 5 Justice Serve TV membership story in this. So I hope I asked all your questions. We didn't want to interrupt Mark with putting the questions on there because it's such a pleasure to listen to him talk and listen to his analysis, which I think is fabulous, Michael. I hope you feel a little better about the judge now.
No. I feel as strongly as I do about Mark, but the judge has to prove himself. Sorry. And so far, it hasn't happened. Do you want to do some of these things because I know we both have hard
I think we did. I think we did most of them. I think we also talked about Mangione. We should. I don't even think we need to do a rip and read. Becky Hill pled guilty to showing some sealed exhibits.
Yeah, so she's doing no time. She'll do no time. But it may have an interesting impact on the new trial motion that is being brought on behalf of.
And we'll talk about that.
Yeah, we'll get into that. We should do a snack on that, just a kind of update. With that,
a little snack, and hopefully we're going to have Serena Townsend on soon to talk about the Mangione case. That'll be another whole. We
kind of want that to be submitted, if not resolved, right? So we can get full
Yeah.
take on it, because they've had
And
some
then
interesting
I will
evidence
just say one thing.
stuff.
I just don't trust the Commonwealth. I just don't trust the Commonwealth for
No.
doing what they have to do, using whoever they have to use to try to go after Aiden Carney to try to win at all costs. So
Of course.
I just don't trust them. So I
No.
will just say that as a matter of public record. And as you all
They
know, I represent him,
are-
but I said that before. I represent him.
And it may be trickling south. Who knows? But it's just this feeling
I
like
can't comment on that.
we're not backing down. We're not. We're coming after him. And Karen, if we can somehow shoehorn her into it, we'll do that too. It's just ignorance and pride. It's such a cliche for the Boston area. I have to say that. It just I know folks who've grown up there, and it just perpetuates itself. And Mark mentioned it. He calls it the what did he call it there? The culture of corruption. It's sad. It's sad for those who have to live there and kind of exist under it. It's just a cloud that could just rain on anybody. Okay, should we do
tomorrow? You're going to be doing just before we forget. Brian Walshe, day 7. You usually have a little snack question at lunchtime, and we'll be going up one day this week. You don't know which day it is. I just want to point that out.
Don't know for sure. I'm trying to judge based on witnesses, and I'm not getting any help in terms of I'm not getting coming attractions. Early on we were, now we're getting nothing. I'm thinking it's going to be the later part of the week, just to give me a little extra help in figuring out who's next. We have a couple of minutes left. Can we look at this, just a little quick clip of this? Because I want to get your take on this. Yeah. This is testimony from Atkinson, the ME, but this is cross-examination. I know it's something you appreciate, the ability to do.
I actually listened to this today. I listened to
it was so well done and such a smart play. This is let me find the right one here. This is the cross-examination, just a clip of it, just a quick clip by Mr. Tipton of Dr. Atkinson. And this is the perfect example of how you turn somebody else's, not necessarily expert, because he's really a precipient witness, but he has expertise that you would love to have, right? If you're arguing, as they are in the defense here, that it was an unexplained death, right? Unexplained death, and my client didn't do it.
One of the things that the Office of Chief Medical Examiner here in Massachusetts does is it's responsible by law to investigate various forms of death, correct?
Correct.
And that includes death by accident or unintentional injury, suicide, correct?
Sure.
And it includes death that is under suspicious or unusual circumstances, correct?
Yes.
And in fact, it includes death that may occur if somebody's in jail custody or something like that, correct?
Correct.
It also specifically includes a requirement that you investigate sudden death, correct?
Correct.
And it requires that you investigate sudden death when the decedent was in apparent good health, correct?
Correct.
And that phrase that I just used, sudden death of the decedent who was in apparent good health, that is contained in the statute that applies to the Office of Chief Medical Examiner, isn't it?
I believe so, yes.
And so the statute and what you do as a medical examiner, you have to investigate where there is a suspicion or information that suggests that someone suddenly died, correct?
Correct.
And specifically where somebody suddenly died that otherwise looked like they were in good health, correct?
Correct.
And that statute requires that certain people, like police officers, physicians, hospital administrators, licensed nurses, DCF social workers, funeral directors, they are required by that statute to report that information to the Office of Chief Medical Examiner, aren't they?
Yes, they are.
Or they could be fined under the statute, right?
I don't know that for sure, but I'll take your word for it.
Okay, thank you. So now turning to just manner of death. Manner of death can be, and please correct me if I'm wrong, a manner of death can be classified as accident, correct?
Correct.
Suicide,
Yes.
homicide,
Yes.
and then there's a category of undetermined or could not be determined, correct?
Correct.
Is it fair to say that a determination, or I'm sorry, a manner of death that results in a classification of undetermined is a classification when the information pointing to one manner of death is no more compelling than one or more competing manners of death after considering all the information you have?
That is correct.
Now, I think he gets into a little trouble here because when there's no body, it's kind of, well, why couldn't you figure out manner? Well, you got no body. But important how he was able to tell this jury through this witness that unexplained, sudden, unexpected death is a thing. And he goes
told
on.
him about 10 to 20%.
Oh my gosh,
It was
5
like
to
unbelievable.
10%. I
5
was
to
shocked
10%.
at that number.
Yeah, but
and
I think he's
even-
talking. I think he's talking, and not in the place where somebody's gotten rid of the body. He's talking.
Of course, of course. 'Cause we
somebody
don't know
drops dead of a heart attack, and they didn't know they had a blocked LAD,
or,
right?
yeah, an aneurysm or deep vein thrombosis or any of those things. Obviously, there's a big part missing here. We don't have a body. But to educate this jury, and that's all I point out. People don't go crazy. Oh my God, they're trying to alibi for Brian Walshe. No, I'm appreciating the craft and how it helps this jury understand that maybe our defense is not so wacky. That there is such a thing as this unexplained death, and the fact that my guy nudged her twice, she didn't move, fell out of bed dead, maybe is not so outrageous. And he went on to talk about arrhythmias and pulmonary problems and neurological problems, all these issues that can lead to sudden unexpected
You
death.
can have a heart infection that you don't know about, right?
So many things, even though she was, by all accounts, healthy. But anyway, I thought that was important from today.
I think it was
such a high point for today.
Larry Tipton's a great cross-examiner and did a great job with regard to that. The problem is that I think usually you talk about it, but I don't know if the prosecution didn't really rehab him by saying, why should you usually talk about that in terms of when there's a body and you want to explain why this person dropped dead in the middle of the street walking, or a runner, he's run the marathon.
Yeah, remember Jim
all
Fix?
Of a sudden Jim Fix was a drop dead. And I don't think the prosecution was too on their, the withers right there, and then gone back and said that to him.
I'll point out one question. I won't show you, but the question was, you've not seen unexpected death in a case in which there were no injuries, have you? He said, yes, I have. And then there was like a pause, like, oh shit, that was not exactly. Don't ask the question if you don't know the answer, dude.
Yeah.
So anyway, I think, is it going to win the day? I doubt it, but I think it's important to recognize
excellent
those skills.
It's right. It should be taught of how you cross-examine somebody.
I mentioned after talking about it today that's something that, in a trial practice type situation, you might be taught,
right,
Professor. So,
no, it was excellent cross-examination. It's just that this may not be the case with regard to that. Your case for people doing drugs, and we all know the cases. People get scared if somebody dies. There's Scandorito. We keep mentioning it. You Google it all. Somebody dies, you think that they died of a heart attack because they were taking drugs. You're going to get blamed for felony murder or something, so you get rid of the body. Here the problem you have though is you have blood, and if it turns out that it's not his blood and it's her blood, and it's not his bone chips and it's her bone chips, then you may, it's
no doubt you're going to have you're going to give the jury all they need to infer that it was murder that he carried out ahead of time.
But maybe not first degree. But maybe
I think second degree, and I've had that conversation from the beginning, and I'm curious to see what happens when they get to the instruction and verdict phase. Is that going to be thrown in there? And it really is, the difference is, do you ever get out on parole or not? And that's the real distinction in Massachusetts. 25 years, they'll give you a shot to getting out. First degree.
Well, he's never getting out because he's going to get sentenced on the fraud.
Well, he's got
Andy Warhol.
He's already been sentenced. That was 37 months. So he's already sentenced.
He hasn't done that, right? He hasn't done that.
Well, that's what I've read today as we were going into. I actually had the pictures of the Warhols today, and I pulled them up and said, "Here's the ones he sold. Here's the ones that," and they both look like shit. They're just horrible. But somebody was willing to pay 80 to 100 grand for them.
Does he have to get up on the stand too and say, well, I found her dead, and I know, people, we had open discussions. I knew that she had the boyfriend. I knew that but I figured people were going to blame me, and there was nothing I could do. I had to get rid of the body. I didn't want to,
Scandorito.
Scandarito, and you all heard that she, from her boyfriend, that she loved me. She had no intention of leaving me, but I thought that in the justice system, I've seen it misfire, and I thought I was going to get blamed. And I've got my
Yep.
2 little kids here, and I just happened to bring them along as I bought $500 worth of cleaning supplies to clean up after I cut up the body. So I just bought one of my
Yeah.
kids along with me. for
And
a
that's why
shopping
there
trip.
was virtually no cross to any of those videos or supply purchases because, yeah, we already said what he did. So we're not
Yeah.
suggesting that buying those chemicals was not true. He did. There he is. Anyway, so
Interesting.
last
guy.
time and I'd love to see him take the stand. I just don't think he's going to be able to pull off the Scandarito. Last time I had tennis, I'm heading off to tennis. I had a tennis shirt under it, had a
Okay.
certain banded collar.
Yeah.
And people were like, "Oh, that T-shirt underneath that was horrible." So now I'm wearing this to tennis. I hope it's okay. I hope people aren't upset. It's not a banded, a regular T-shirt.
Wait a second. Let me just, before you run off, let me just read my paper. Oh, let me just read my paper. Let's see. Chanel comes to New York. That's you, Michael Bryant.
That's
There you
just
are.
your
You're in
house.
ASAP
Just-
Rocky is now the Chanel spokesman for they're going to probably have a
Isn't that
men's
nice?
line. So I think that probably this is really for you as we continue our quest, and we haven't.
I just
finished
sent out
with
some
the-
emails today on that front. We're working on getting some information from the ASAP Rocky trial that has not been
right.
disclosed that we want to get out there to you. So we'll keep you posted as that unfolds. Okay. All right. So I'm going to go play tennis in this shirt. I hope it's okay.
Subscribe, like, share, notify, and Michael will see you at lunch tomorrow, Lawyers Lunch, and I will see you at 6 p.m.
And that's the best we can do for tonight. Glad you joined. Mark is amazing. We'll see you next time. And in the meantime, try to do the right thing.